that is training program will be aware about Safi Mohan sir and his motivation as a teacher to get to the maximum potential of each and every student. I am a living example. I have told this in many other places also when I'm taking classes under the label of LJRF. I'm very much proud that I'm his student and I've attained my whatever potential that I have because of him, only because of his motivation. And thank you so much, sir. And now about this class, Safisa has told me a month before, but due to some personal hardships and problems, I was not able to my ill health. I was not able to take class at that time. Now I am happy that I am okay, and we will go straight to the class now. The topic that I've chosen is gift under the Transfer of Property Act 1882. So, what is gift under the TP Act? It is always a happy thing that we someone is giving us a gift. What's the speciality of a gift? Whatever gift may be, just ignore about the transfer of property and anything. Gift is something we don't need to give anything in return. It arises out of our love, affection, whatever it is. Someone is gifting us, so we can receive it without giving it anything in return. In simple terms, that is gift. But just think about we are getting a thing and we are paying them. That is said. We are paying them money. That is said. And we are getting something in return. We are giving some object or thing. It is exchange. So what we are going to learn about is gift. We are receiving and we just give a smile, happiness. That is gift. It is given to us because of the love and affection. So to make it formal, to make it legal, Section 122 of the TP Act um, just tells us about what is gift. Gift is defined in the TP Act as transfer of certain existing movable or immovable property made voluntarily without consideration by one person called donor to another person called donee and accepted by or on behalf of the donee. I'm sure that the PPT is very much visible to you. I have bold each and every word which is very much important in this definition. Just go through it. Gift under TP Act is the transfer of certain existing movable or immovable property. The property should be existing. It can be movable or immovable. How? Made voluntarily without any coercion, undue influence, fraud, or misrepresentation. That is voluntarily with one's own will and without consideration in return. He's not getting anything. And who is this doing? The person who is giving this gift is called donor. Who is transferring this mobile or immobile property is called as donor. To whom? To the person called donee and accepted by the donee himself or on behalf of the someone else on behalf of donee. Very much simple and easy definition, right? So we are going through this definition of gift. Acceptance. Who is making the acceptance? I am a donor. I am giving something to you, and you are donee. So you are the one who is to accept the gift that I am giving. So when that acceptance to be made by you, the acceptance to be made is during the lifetime of the donor, and I am the donor who is still capable of giving. Only the acceptance can be made during the lifetime of the donor and only when the donor is capable of giving that particular gift. So, next, absence of consideration. As I said, it is the essential element of a gift. There is no consideration. You know what is consideration. You have studied in the contract that I'm sure that no consideration. You can just smile and take the gift. There is nothing to give in return. That's the essential element of the gift. And as I said, it's a transfer made out of natural love and affection. And a gift can be either inter vivos. What is inter vivos? Inter vivos, the word means between living persons. Inter vivos means between the living persons, or gifts testamentary. What does that mean? Will operate only after the death of the transferor or testator, the one who transfer. So, among to the essentials of a valid gift. What makes a gift valid? What are criteria does a valid gift have? So, as I said, there must be a transfer of a specific, actual, movable or immovable property. The property can be ascertained. The property must be existing. It should be specific. What does that mean? But it means that there can't be a gift of a future property. The property should be existing actually. It should be real, not future. Property can be gifted, and it can be, the subject matter can be corporeal or incorporeal. As being a law student, I'm sure that what corporeal and incorporeal are meaning. You people already know that. Corporeal means what it can be seen, felt, or incorporeal. It exists, but it can't be seen or felt. And an actionable claim can also be validly gifted. An actionable claim, an arrears of rent is one of the best example of actionable claim. It can also be validly gifted. The gift should be voluntarily made and without consideration. Voluntarily means with one's own free will. No coercion or undue influence or fraud or misrepresentations should be taking place while one person is giving a gift. In the case of Khartari versus Gopal Krishnan, it was held, you can note the cases also, it was held by the court that a gift deed executed by an old widow under undue influence and fraud is void. So, as I said, donor is a person who makes a gift, and he should be a person who is also competent to contract. What are the essentials of a person to be competent to the contract? He should attain the age of majority, if not be lunatic, and he should not be barred by any law, any specifically from making a contract. Just like in the Contract Act, he should be a person competent to contract, and in that view, minor cannot make a gift of his property. So, and a donee is a person who is accepting the gift, as I said, and the gift must be accepted by the donee or by someone on his behalf. And the donee must be a person who is an ascertainable person. He should be traced, or he can be ascertainable. He should be an ascertainable person, and such acceptance made by the donee must be made during the lifetime of the donor, as I said, and while he is still capable of giving. If the donee dies before the acceptance, not the donor, if the donee, the person who is receiving the gift, he is the one who is going to make the acceptance, fail to make the acceptance before his death, the such gift is void because he has not accepted that gift. And this particular acceptance by the donee can be, may be express or implied. So, Section 123 of the TP Act enumerates how such transfer is effected. For the purpose of making a gift of immovable property, note that it is an immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor, signed by the donor or his behalf, and attested by at least 2 witnesses. I'll read it out once again. For the purpose of making a valid transfer of an immovable property, the transfer must be effected by a registered instrument signed by or behalf of the donor and attested by at least 2 witnesses. And for the purpose of making a gift of a movable property, the transfer may be effected either by a registered instrument signed or as aforesaid, or by the delivery. What do you mean by delivery? Just like a delivery made in the same way as goods sold may be delivered. And a gift deed registered by the donee after the death of the donor without the consent of the legal representative is still valid, as it is not necessary that the deed should be registered by the donor himself. It means a particular gift deed is registered after the death of the donor by the donee without the consent of the legal representatives of the donor is still valid because the deed should there is no particular stipulations that a particular deed should be registered by the donor himself. Even the donee, after receiving the gift deed, can validly register the gift deed by himself. So we can go through certain case laws under the purview of gift under section under the TP Act. The first case is Saina Mandir Trust versus Vijay and others, and it was held in this case that document is in the nature of a dedication of immovable property to the god, does not require registration as it constitutes a religious trust and it's exempt from registration. And in Gandewala versus Jairam Reddy versus Mokala Padmavatama and others, it was held that Pasupa Kunkuma, it is a ritual like uh, happening among the Hindus, gift giving to the daughter as a property, and it is considered as a gift and settlement or assignment of land made to daughter. Thus, it comes under the purview of gift under section 123. What it means is that the registration is a compulsory. The court held that the registration of Pasuma Kankuma is compulsory. And in Serandhya Pilla and another versus Sankaralinga Pilla and another, it was held that where a transaction is a gift of immovable property, it should be registered and effected in writing. Just keep in mind that when it is an immovable property, the gift should be registered and effected in writing as aforesaid. It is the case law also says the same thing. So void gift, we are coming to the void gift. What are the gifts which are void under the TP Act, which is not valid? What are the certain gifts which are not recognized as a valid gift under the Act? First, what is the Act? A gift comprising both existing and future property is void as to the latter. What does that mean? A single gift may have both existing and future property in it. So how that gift become a valid gift? That gift become valid only as to the former thing, that is what existing property, and it is void to the extent of future property in that particular transfer. It can be a single transfer, and that existing property will be void and future property is will be considered as void as to the uh, as to the latter. And a gift of a thing to two or more donors of whom one doesn't accept. If a particular gift is given to two or more persons and one person is not accepting the offer, it is void as to his extent. That portion remains void, and the other persons who accept the offer or accept the gift can take it as a gift, and it remain void as to his part. And a gift, and the third criteria is a gift made for an unlawful purpose. It's pretty sure and pretty understandable that for unlawful purpose a gift is made, it is considered as void. And also under section 124 of the TP Act enumerates that a gift of income to arise in the future is void. You cannot gift your income, your future income, to any other person out of your love or affection, and it can't be considered as a gift under the transfer of property section 124. So a gift of income to arrive in the future is also considered as void. Then a gift depending on a condition, the fulfillment of which is impossible or forbidden by law. There can be a condition subsequent when you are making a gift. You can make certain conditions, but that fulfillment of that condition should not be impossible or forbidden by law. So such conditions, a gift which is depending on such conditions, the fulfillment of the same is impossible or contrary to law or forbidden by law, is considered as a void gift. Next criteria is, as I said earlier, the donee dies before acceptance. Only after valid acceptance, the gift also becomes valid. If I am giving you a gift, there should be a proper acceptance from your part. Just like in the contract, offer plus acceptance only make a valid agreement. Just like that, if I am making a gift to you, you should accept that gift. But when the donee dies before making a valid acceptance, the gift itself becomes a void gift. Next thing is a gift which under an agreement between the parties is revocable wholly or in part at the mere will of the donor. Just go through the bolded words in this PPT, so you can get a clear-cut understanding about what all gifts are void gifts. The first, look at this first thing is impossible or forbidden by law. Next is donee dies before the acceptance. Third is incompetence to contract. Gift by a person incompetent to contract. Who are incompetent to contract? As I said, who is a minor, who is a lunatic, and who is specifically barred by any law from making such contract. And all these things make a person incompetent to contract. And if such a person act as a donor who makes a transfer, that particular gift itself becomes a void gift. And next one is a gift which under an agreement between the parties is revocable wholly or in part at the mere will of the donor is void wholly of or in part as the case may be. What does that mean? If I am making an agreement with you that a condition with you that if I am the donor, I'm making a condition to you that I will revoke the gift at the mere will of mine. Whenever I think, I'll take that gift back away. I can't say that. Once I am gifting you a certain thing badly, I can make certain condition as to the happening of certain events. But I can't just say that I'm revoking this gift at my mere will. Such a gift will become void. If I am making an entire revocation at the mere will of me, give me that gift back. Just my mere will. I am saying whenever I am thinking, the entire gift become void. If I am making certain parts of the gift, this part of the gift is mine. Whenever I will think or whenever at my will, I will recall it or revoke it. You should give me such kind of gifts are void gifts. Entirely, if I am revoking it, the entire gift will become void, or that certain parts I am reserving, then that part of the gifts will also become void.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional